Roe v. Wade, 1973, was a landmark decision of the U.S. Supreme Court in which the court ruled that the Constitution of the United States protects a pregnant woman's liberty to choose to have an abortion without excessive government restriction. The decision struck down many U.S. federal and state abortion laws. Roe fueled an ongoing abortion debate in the United States about whether, or to what extent, abortion should be legal, who should decide the legality of abortion, and what the role of moral and religious views in the political sphere should be. It also shaped debate concerning which methods the Supreme Court should use in constitutional adjudication. The decision involved the case of Norma McCorvey, known by the legal pseudonym Jane Roe, who in 1969 became pregnant with her third child. McCorvey wanted an abortion but lived in Texas, where abortion was illegal except when necessary to save the mother's life. Her attorneys, Sarah Weddington and Linda Coffey, filed a lawsuit on her behalf in U.S. federal court against her local district attorney, Henry Wade, alleging that Texas's abortion laws were unconstitutional. A three-judge panel of the U.S. District Court for the Northern District of Texas heard the case and ruled in her favor. Texas then appealed directly to the U.S. Supreme Court. In January 1973, the Supreme Court issued a 7-2 decision in McCorvey's favor, ruling that the Due Process Clause of the 14th Amendment to the United States Constitution provides a right to privacy that protects a pregnant woman's right to choose whether to have an abortion. It also ruled that this right is not absolute and must be balanced against government's interests in protecting women's health and prenatal life. The court resolved this balancing test by tying state regulation of abortion to the 3 trimesters of pregnancy. During the first trimester, governments could not prohibit abortions at all. During the second trimester, governments could require reasonable health regulations. During the third trimester, abortions could be prohibited entirely so long as the laws contained exceptions for cases when they were necessary to save the life or health of the mother. The court classified the right to choose to have an abortion as fundamental, which required courts to evaluate challenged abortion laws under the strict scrutiny standard, the highest level of judicial review in the United States. The court's ruling in Roe was criticized by some in the legal community, and some called the decision an example of judicial activism. The Supreme Court revisited and modified Roe's legal rulings in its 1992 decision Planned Parenthood v. Casey. In Casey, the court reaffirmed Roe's holding that a woman's right to choose to have an abortion is constitutionally protected, but abandoned Roe's trimester framework in favor of a standard based on fetal viability and overruled the strict scrutiny standard for reviewing abortion restrictions. On May 2, 2022, Politico obtained a leaked initial draft majority opinion penned by Justice Samuel Alito indicating that the Supreme Court is prepared to overturn Roe and Casey in a pending final decision on Dobbs v. Jackson Women's Health Organization, expected to be issued by June 2022. A press release from Chief Justice John Roberts the following day confirmed the authenticity of the leaked document, but stated that the draft does not represent a decision by the court or the final position of any member on the issues in the case. Sarah Weddington recruited Linda Coffey to help her with abortion litigation. Their first plaintiffs were a married couple. They joined after the woman heard Coffey give a speech. The intended suit would state abortions were medically necessary for the woman. The woman had a neurochemical disorder and it was considered medically necessary that she not give birth or raise children, yet they didn't want to abstain from sex, and contraception might fail. The attorneys were concerned about standing since the woman was not pregnant. Weddington later wrote that they needed to find a pregnant Texas woman who wanted an abortion and would be willing to be a plaintiff. They also wanted to increase the likelihood that the panel selection would help them win in court. They wanted to present their case to a 3-judge panel which included a judge they thought would be sympathetic. If one of the 2 cases was assigned the way they wanted, they intended to combine the cases under the one with the favorable assignment. At first she was unsuccessful in finding a suitable pregnant woman. In June 1969, 21-year-old Norma McCorvey discovered she was pregnant with her third child. Ordinarily, lawyers are not allowed to directly solicit clients without any prior relationship, but McCorvey's situation qualified for an exception in the no solicitation rule, which allows lawyers to solicit new clients for public interest cases. McCorvey, according to a sworn statement made in 2003, asked if she had what was needed to be part of the Weddington and Coffey's lawsuit. She recounted being told, "Yes. You're white. You're young, pregnant, and you want an abortion." Both McCorvey's whiteness and her lower social class were crucial factors in the attorney's choice to have her as their plaintiff. McCorvey also recounted that the lawyers asked if she thought abortion should be legal. McCorvey said she didn't know. Weddington told her, "It's just a piece of tissue. You just missed your period." This convinced McCorvey that abortion should be legal. She agreed to let them represent her under the impression that she would be able to eventually get a legal abortion. She smoked an illegal drug and drank wine so she wouldn't have to think about her pregnancy. McCorvey gave birth to a daughter at Dallas Osteopathic Hospital on June 2, 1970. The baby was adopted by a couple in Texas. In 1970, Coffey and Weddington filed suit in the U.S. District Court for the Northern District of Texas on behalf of McCorvey under the legal pseudonym Jane Roe, and also on behalf of the others. The defendant in the case was Dallas County District Attorney Henry Wade, who represented the state of Texas. Weddington later stated the lawsuit was part of a much larger effort by many attorneys whose collective interests she represented. James H. Halford was a physician who stated that he had been arrested for performing abortions. The court allowed him to join the suit as a physician intervener on behalf of the plaintiffs. Their judicial panel strategy worked. One of the cases was assigned to the panel of judges, which included the judge they thought would be sympathetic, so the two attorneys filed for both cases to be consolidated and heard by that panel. McCorvey's lawsuit was heard by a three-judge panel consisting of District Court judges Sarah T. Hughes and William McLaughlin Taylor Jr. and appellate judge Irving Loeb Goldberg of the U.S. Court of Appeals for the Fifth Circuit. Judge Hughes knew Coffey, who clerked for her from 1968 to 1969. On June 17, 1970, the three judges unanimously ruled in McCorvey's favor and declared the Texas law unconstitutional, finding that it violated the right to privacy found in the Ninth Amendment. The court relied on Justice Arthur Goldberg's 1965 concurrence in Griswold v. Connecticut. The court, however, declined to grant an injunction against enforcing the law, and ruled against the married couple on the basis that they lacked standing. Roe v. Wade reached the Supreme Court when both sides appealed in 1970. The case continued under the name Roe v. Wade instead of being switched to Wade v. Roe. The justices delayed taking action on Roe and a closely related case, Doe v. Bolton, until they had first decided certain other cases. One case they decided first was Younger v. Harris. The justices felt the appeals raised difficult questions on judicial jurisdiction. Another case was United States v. Vich, in which they considered the constitutionality of a District of Columbia statute which banned abortion except when the mother's life or health was endangered. The court upheld the statute on the grounds that the word health was not unconstitutionally vague and placed the burden of proof concerning dangers to the life or health of the mother on the prosecutor instead of on the person who had performed the abortion. Justice William O. Douglas wrote a lengthy dissenting opinion to this case. He argued that the right to marital privacy and the limitation of family size from Griswold v. Connecticut also applied here, although he acknowledged that on the other side is the belief of many that the fetus, once formed, is a member of the human family and that mere personal inconvenience cannot justify the fetus destruction. He also challenged the majority opinion with a series of hypothetical questions asking whether health might also include the stigma of having an illegitimate child, anxiety from the pregnancy being unwanted, the physical work of raising a child, the financial drain from the added expense of another child, and far-off health risks that may never actually materialize in a similar fashion to how risks were warded off with prophylactic appendectomy. Douglas's dissent made a similar legal argument to the one used 2 years later in Roe v. Wade. The following day after their decision was announced, the court voted to hear both Roe and Doe. According to Blackmun, Stewart felt the cases were a straightforward application of Younger v. Harris, and enough justices agreed to hear the cases in order to review whether they would be suitable for federal as opposed to only state courts. This sort of review was not about the constitutionality of abortion and would not have required evidence, witnesses, or a record of facts. The oral argument was scheduled by the full court for December 13, 1971. Before the court could hear the oral argument, Justices Hugo Black and John Marshall Harlan II retired. Chief Justice Warren Burger asked Justice Potter Stewart and Justice Blackmun to determine whether Roe and Doe, among others, should be heard as scheduled. They recommended that the court continue on as scheduled. As she began speaking for the oral argument, Sarah Weddington was unaware that the court had decided to hear the case in order to decide which courts had jurisdiction to hear it rather than as an attempt to overturn abortion laws in a broad ruling. She began by bringing up constitutional reasons why the court should overturn Texas's abortion law, but Justice Stewart asked questions directed towards the jurisdiction question instead. Weddington replied that she saw no problem with jurisdiction and continued to talk about a constitutional right to abortion. Overall, she spent between 20 and 30 minutes discussing jurisdiction and procedure instead of constitutional issues. In his opening argument in defense of the abortion restrictions, Attorney J. Floyd made what was later described as the worst joke in legal history. Appearing against two female lawyers, Floyd began, "Mr. Chief Justice, and may it please the court. It's an old joke, but when a man argues against two beautiful ladies like this, they are going to have the last word." His remark was met with cold silence. One observer thought that Chief Justice Burger was going to come right off the bench at him. He glared him down. McCorvey did not attend either of the oral arguments along with her two lawyers. After talking McCorvey out of getting an illegal abortion and getting her name signed on an affidavit for the lawsuit, Weddington did not speak again with McCorvey until 4 months after Roe was decided. After the first argument session, Burger assigned the task of writing the court's opinions for both Roe and Doe to Blackmun. Douglas suggested to Blackmun that Burger assigned the opinions to him out of malicious intention, but Blackmun disagreed. He knew that Burger could not write it himself because the abortion was too controversial, and his opinions might get rejected by the majority. He also understood why the other justices could not be assigned to write the opinions. Douglas was too liberal for the public to accept his word. Likewise, he might split the court's vote by writing something radical. In addition, the quality of his opinions had suffered recently. Brennan was the only Catholic on the court, and he would have to face Catholic political groups which were against abortion. If Marshall wrote the opinions, the ruling would be perceived as being directed towards African Americans, and he would have to face the displeasure of African American political groups. Stewart would have trouble going far enough in legalizing abortion. At this point, Black and Harlan had been replaced by William Rehnquist and Lewis F. Powell Jr., but the first argument had already occurred before they became Supreme Court justices. Justice Blackmun worked on a preliminary opinion for Roe which argued that Texas's law was unconstitutionally vague. This approach accommodated the claims of some doctors who were concerned that prosecutors might disagree with them over what constituted life. Blackmun thought this approach would be a good way to avoid controversy which would come with saying there was a fundamental right to abortion. Brennan and Douglas disagreed with Blackmun and wrote to him that instead he needed to focus on privacy. After communicating with the other justices, Blackmun felt that his opinion did not adequately reflect his liberal colleagues' views. In March 1972, the court issued a ruling in Eisenstadt v. Baird, a landmark case which applied the earlier marital privacy right now also to unmarried individuals. Douglas wrote to Blackmun in May 1972 that he thought there were 4 judges who were definitely willing to rule in the majority: himself, Brennan, Stewart, and Marshall. Blackmun at one point thought all 7 justices wanted to vote in the majority. In May 1972, Blackmun proposed that the case be re-argued. Justice Douglas threatened to write a dissent from the re-argument order because he and the other liberal justices were suspicious that Rehnquist and Powell would vote to uphold the Texas abortion statutes. He was coaxed out of the action by his colleagues, and instead his dissent was merely mentioned in the re-argument order without further statement or opinion. The case was re-argued on October 11, 1972. Weddington continued to represent the pseudonymous Jane Roe, and Texas Assistant Attorney General Robert C. Flowers replaced J. Floyd for Texas. A June 1972 memo written by Douglas to his colleagues discussing the case was leaked to and published in the Washington Post before the decision was published. Blackmun continued to work on his opinions in both cases over the summer recess, even though there was no guarantee that he would be assigned to write them again. Over the recess, he spent a week researching the history of abortion at the Mayo Clinic in Minnesota, where he had worked in the 1950s. He talked daily on the phone with George Frampton, his 28-year-old law clerk who stayed behind in Washington, D.C. Frampton researched the history of abortion using a book authored by Lawrence Lader, the founding chairman of what is now called NAAL Pro-Choice America. Blackmun's papers made available since his death contain at least 7 citations for Lader's 1966 book, Abortion. Chapter 16 of his book, A Blueprint for Changing U.S. Abortion Laws, predicted that if abortion were to be legalized, the possibility of community opposition is slight. Lader also predicted that if such a theoretical case was carried to a high court, perhaps even the U.S. Supreme Court, and the judges confirmed a broad interpretation of the meaning of a threat to life, undoubtedly a landmark in abortion decisions would be reached. The Historical Survey for Roe also relied on several articles by Cyril Means, who served as counsel to NAAL. In the articles, Means misrepresented the common law tradition in ways that were helpful to the Roe side. Roy Lucas, the principal attorney assisting Weddington and Coffey, had previously received a memo from his colleague David M. Tunderman about Means's scholarship. The memo stated that the conclusions in Means's articles sometimes strain credibility. It also stated, where the important thing is to win the case no matter how. However, I suppose I agree with Means's technique: begin with a scholarly attempt at historical research. If it doesn't work, fudge it as necessary, write a piece so long that others will read only your introduction and conclusion, then keep citing it until courts begin picking it up. This preserves the guise of impartial scholarship while advancing the proper ideological goals. After the court held the second argument session, Powell said he would agree with Blackmun's conclusion but pushed for Roe to be the lead of the 2 abortion cases being considered. Powell also suggested that the court strike down the Texas law on privacy grounds. Byron White was unwilling to sign on to Blackmun's opinion, and Justice Rehnquist had already decided to dissent. During the drafting process, the justices discussed the trimester framework at great length. Powell had suggested that the point where the state could intervene be placed at viability, which Thurgood Marshall supported as well. In an internal memo to the other justices before the majority decision was published, Justice Blackmun wrote, "You will observe that I have concluded that the end of the first trimester is critical. This is arbitrary, but perhaps any other selected point, such as quickening or viability, is equally arbitrary." In the same memo he suggested that the end of the first trimester seemed more likely to get support from other justices and allowed states the ability to adjust their statutes. He was of the impression that doctors were concerned that recovering abortion patients would take up too many hospital beds, and that abortion patients later than the first trimester were more likely to require hospital beds than those whose fetuses were aborted earlier. Contrary to the justices who preferred viability, Douglas preferred the first trimester line. Stewart said the lines were legislative and wanted more flexibility and consideration paid to state legislatures, though he joined Blackmun's decision. William Brennan proposed abandoning frameworks based on the age of the fetus and instead allowing states to regulate the procedure based on its safety for the mother. On January 22, 1973, the Supreme Court issued a 7-2 decision in favor of Jane Roe, Norma McCorvey, holding that women in the United States had a fundamental right to choose whether to have abortions without excessive government restriction and striking down Texas's abortion ban as unconstitutional. The decision was issued together with a companion case, Doe v. Bolton, which involved a similar challenge to Georgia's abortion laws. Justices Byron White and William Rehnquist dissented from the court's decision. White's dissent, which was issued with Roe's companion case, Doe v. Bolton, argued that the court had no basis for deciding between the competing values of pregnant women and unborn children. I find nothing in the language or history of the Constitution to support the court's judgment. The court simply fashions and announces a new constitutional right for pregnant women and, with scarcely any reason or authority for its action, invests that right with sufficient substance to override most existing state abortion statutes. The upshot is that the people and the legislatures of the 50 states are constitutionally disentitled to weigh the relative importance of the continued existence and development of the fetus, on the one hand, against a spectrum of possible impacts on the woman, on the other hand. As an exercise of raw judicial power, the court perhaps has authority to do what it does today, but, in my view, its judgment is an improvident and extravagant exercise of the power of judicial review that the Constitution extends to this court. White argued that abortion, for the most part, should be left with the people and the political processes the people have devised to govern their affairs. Rehnquist's dissent compared the majority's use of substantive due process to the court's repudiated use of the doctrine in the 1905 case Lochner v. New York. He elaborated on several of White's points and asserted that the court's historical analysis was flawed. To reach its result, the court necessarily has had to find within the scope of the 14th Amendment a right that was apparently completely unknown to the drafters of the amendment. As early as 1821, the first state law dealing directly with abortion was enacted by the Connecticut legislature. By the time of the adoption of the 14th Amendment in 1868, there were at least 36 laws enacted by state or territorial legislatures limiting abortion. While many states have amended or updated their laws, 21 of the laws on the books in 1868 remain in effect today. From the actual historical record, Rehnquist concluded, there apparently was no question concerning the validity of this provision or of any of the other state statutes when the 14th Amendment was adopted. Because of this, there apparently was no question concerning the validity of this provision or of any of the other state statutes when the 14th Amendment was adopted.